Okay, I think we've got everyone we're going to get this morning. So welcome to my 45 minutes on effective mediation and how to go about it. As a bit of housekeeping, don't worry about writing down anything on the slides. They will all be sent to you by email afterwards. We'll try and fit in a Q&A at the end of the session. If we don't have time to get through your question, then by all means do drop me a line. Very happy to discuss your experience of mediation. And of course, a feedback survey will be sent at the end as well. So lots to cover today in how to conduct an effective mediation. Now, three topics essentially that we're going to look at. What is mediation and when must you do it? How to prepare for an effective mediation and how to maximize your chances of settlement on the day, which of course is what you are looking to do, because mediation is the shortcut towards avoiding a long-winded litigation. This is a definition you could use, a definition I come together with, a form of facilitated negotiation which, if successful, usually leads to a contractually binding settlement and the end of any legal proceedings, a full and final settlement. Okay, so it's more than negotiation in that you have a third-party mediator present. And for that reason alone, it has a much greater prospect of success, in my view. You have a third party who's independent, and we'll go through the role of a mediator shortly. But having that third party there makes it very different towards, in comparison towards a negotiation around a round table or through correspondence or anything like that. Now, it is a form of what we call alternative dispute resolution, ADR. To define other forms, you're looking at litigation, which is obviously in a court, arbitration, which is similar but under different rules, adjudication, which is swift and dirty, expert determination, which is on specific issues usually, and where you want an expert who really understands a topic rather than a judge. Now, to give you a picture, if you haven't been in a mediation before, of what you're looking at, it's 3 rooms, 2 parties, 1 mediator, 1 independent mediator who isn't known to either party in particular, who comes fresh to the issues, sits down with the 2 parties, operates between 3 rooms, so you've got privacy if you want to with the mediator, or you can come together in a joint session, and facilitates the discussion and hopefully settlement by exchanging information on a very specific basis between the parties. Okay, and that is to say the parties can confirm which information they wish to pass across and which information they don't. We'll come on to that in a little bit. You can use mediation at any stage. You don't have to have live litigation ongoing in the background. You just have to have a dispute, and that can be in the very earliest stages. It can be in the form of a letter notifying of a dispute, either contractually or even not under contract, or you could be right up against a trial. Okay, there's all sorts of times you can start a mediation, and as such, it is an integral part of the modern civil justice landscape. Okay, the courts really do expect parties these days to engage in considering whether any form of ADR is appropriate. Often that ADR form in the general cases is mediation, where there is not another form of ADR specified. And this is built into the rules that we operate in when we are advising you and when we are litigating a case for you. Okay, there's the overriding objective built into the civil procedure rules, which are the rules that deal with the civil justice system, basically. And underlying these is that you must deal with the case in a just and proportional manner. That means the court must do, the parties must do, and we as solicitors must do for you. Okay, and we must save expense wherever possible, deal in cases which are proportionate to the level of money involved, the importance of the case and the complexity of the issues and the financial position of the parties. So a very wide-ranging objective there. This is also built into the pre-action practice directions and protocols. Now, these are what govern our communications with the other side in pre-action stages. Okay, we must consider mediation and other options at that stage. We've got a duty to advise you of that, and we would do so in any case to make sure that you are maximizing your opportunity to mediate if it can be done. And if you don't do it, the courts will hit you with a cost implication, which means that even if you win the case, you might actually not get your costs paid. Okay, the standard position, of course, in litigation is if you win the case, you get your costs. There's many reasons why you might not get that, depending on the level of the case or the whether there's been a Part 36 offer, or that's a specific offer with cost consequences. But the general cost implications are potentially that if you refuse to mediate and that refusal is unreasonable, then you may not get your costs. We'll look at that in more detail in a moment. Litigation versus mediation. Very simple table here. everything you would think about litigation is these days very, very true. It's slow. COVID hasn't assisted that, but it's always been slow. You're waiting a long time. You're expecting at least 18 months often for a decent sized hearing. They're public, whereas mediation, of course, is private. They're resource heavy for a long period of time, whereas mediation is over in a very short period of time. And you have a lot more control in mediation than you do when you are simply relying on a judge making the decisions, which might not ultimately be what you see to be the most desirable outcome, or what either party sees to be the most desirable outcome. Okay. Last point on here, actually, I will skip down these, but the last point on here is the benefit of using mediation where you have to maintain a relationship with the party that you're in dispute with. Often in litigation, that is simply out of the question. But if you can mediate a solution that perhaps doesn't involve putting the party into liquidation, obviously you're in a better state towards keeping that option open towards working with them if you want to in the future. So first off, we should consider, are you contractually obliged to mediate? You look at the DRP clause, the dispute resolution procedure clause, which is somewhere towards the back of a contract usually. You look for the service of a dispute notice, and then what happens after that. Typically, there is a process by which the senior management will become involved, and at some point you may be required or allowed to mediate. Now, parties are always allowed to mediate, but it may be explicitly put in the DRP that you may be or that you shall mediate. And if you must mediate, then you must mediate. That's a contractual obligation. Okay. There's other options that can trip into the DRP clause, which can be requirements to adjudicate and arbitrate, and those need to be followed. And there may also be needs to go to court to protect your interest in the short term, which may mean an injunctive remedy, an urgent application to the court for something to be done immediately, and that may mean that you do that before you go to mediation. Okay, but that needs to be, you need to check as a first point of call. If you have an underlying dispute which has an underlying contract, then you look at the DRP clause and see what the provision is for mediation and other ADR options. As a side note, just check also, similar part of the contract, you usually find a jurisdiction and a choice of law clause. And of course, that's important because even if you mediate, you need to know what the underlying law is going to be so you can discuss what the likely outcome at trial would be. And therefore, you need to know what the jurisdiction and choice of law is. Otherwise, you're arguing essentially apples and oranges if you're litigating in US law, but it's actually a UK mediation. Not to say you can't do it, but you need to be aware of what's going on there. Okay. Now, case law, I'm not going to throw too much case law at you, but this is a key case. This basically goes back to 2004 and establishes that if you unreasonably refuse to mediate, there can be cost sanctions. And these housey factors, these housey principles are what are looked at by the court to determine whether or not your refusal to mediate was reasonable. And as you can see, it can take into account a range of things, and it is not a complete list. The courts can take into account other matters as they crop up. And indeed, the courts have interpreted these over, the time since 2004. And there are specific cases dealing with these issues. But you can look at various parts, such as the nature of the dispute. Now, there is nothing to say that the nature of a dispute necessarily lends itself towards ADR or mediation, but it may be that some are less suitable towards mediation on the face of it. The court, as it happens, will not take that as a generality. They won't say, well, this is a type of case which just is not suitable. Generally, the vast majority of disputes will be seen as suitable, and they will the court will look at them very specifically when considering an argument that because of the nature of the dispute you were right to not proceed to mediate, and that then runs into the merits of the case as well. So just because you think you have a strong case doesn't necessarily mean that there's a reasonable basis on which not to mediate. So is the dispute suitable for mediation? Now, mediation, as I say, keeps the parties in control. And so there's flexibility over the outcomes. You're not just looking at a judgment. You're not seeking to agree a form of arrangement where one party pays the other X million pound and that's the end of it. You can have payments over time. You can have a revision to the existing contract or a completely new contract taking the place of the contract that was breached or was in dispute. And you can have apologies, which in some cases actually goes a long way towards resolving issues. I'm not saying all matters can resolve in that way, of course, but you'd be surprised even in quite commercial matters that an apology can go a long way towards bridging a gap between what payment you might accept and what payment you actually do end up accepting. So I would say that in the vast majority of disputes, there is, 99% of disputes, there is a position for mediation to be used at some point. The fact is that, as I say, there are certain circumstances where you may need to go to court to protect your position by perhaps injuncting the other party, to prevent loss of funds or loss of material that you want recovered as part of the claim, and that obviously has to take place. But then a mediation can follow up afterwards. Now, even if both parties agree that perhaps that there isn't the mediation is the dispute is not suitable for mediation, then there's still some potential tactical advantages, because what you're doing in mediating at an early stage in a dispute is you are testing your case. You are putting an argument to the other side, and you're seeing what they say. And so you may be able to actually learn more about the other side's case than you give away about yours. And you might be able to get their view on your arguments at an early stage, perhaps before you've even gone to the expense of pleading it out, putting in a formal particulars of claim or a defence. Before you've gone to the cost of doing so, you can actually test those arguments out and just see whether they have an answer to them. Perhaps they can say, well, you argue this point, but what about this document? And it enlightens you as to documents you didn't realise existed that go against your case. That circumvents a lot of time spent dealing with the pleadings and potentially disclosure halfway through a case. Now I put down here at the bottom the unknown, and that's simply to say you don't know exactly what people are likely to come to the table with. You don't know whether there's an offer there that you haven't anticipated that you might be happy to accept. And I think it's important to recognize that when you're dealing through lawyers, sometimes things get lost in translation, and you might not appreciate that the other side actually has a desire to settle, because that's not coming out through their correspondence, which is filtered through their lawyers. I've seen it happen before, and it's as I say, the unknown factor, the X factor, if you will, of going along and seeing what happens on the day. Now, examples of suitable disputes. This is a complete range of matters similar to things that we've dealt with. I've sort of drawn on that, but it gives you an indication from the top to the bottom there. You've got many multi-million-pound contracts down to a simple three-party dispute between a yacht owner, a shipwright, and an insurer, for relatively low sum of money. But you can really use mediation at any level, from disputes ranging into the billions to disputes ranging into the few £1,000s. Also, you go to different mediators for that, and you incur different levels of costs. But it is a process that works across the dispute board. I mean, way back when I was in university, I used to do mediations between neighbourhood disputes. Literally neighbours living one side along another. So it worked there, and it works in dozens and dozens of matters that we deal with. Bit of case law. Can you argue that the parties are too far apart to mediate? Generally, no. Now, in this case, the judge actually went as far as ordering indemnity costs, which is simply a higher level of cost recovery against the defendant, when they refused to mediate consistently. So the court noted the parties would not know how far apart they were until they tried. I think this just goes to underline the fact that you are really taking a bit of a risk if you don't seek to mediate, unless the other side are being completely unreasonable, perhaps in their conduct, in the information that they're sharing with you, or the basis on which they will mediate. You need to show a general willingness to mediate on reasonable terms at a reasonable time. So again, recent case from 2020. Can you argue that a case is too strong to bother mediating? Again, indemnity costs were applied, so that higher level of cost recovery, that cost punishment issued by the court. The court considered conduct was out of the norm, and that no defence, however strong, was by itself a justification for not engaging in any ADR. Now, usually, of course, if you have a case which is very similar to a previous case, you go along to court and you argue that there's a precedent for your argument, and that therefore the court should follow that precedent and give you the what you are seeking as a judgment. Now, that in itself is not always sufficient, okay? And you have to be very careful if you were to rely simply on a precedent to say there's no point mediating because my case is so strong, it's backed up by previous case law, no point in going about a mediation. That is not sensible. The court may punish you for it. You do not know necessarily what the other side is offering. You may get a better outcome if you mediate. You may get a payment over time that is better than if you get a judgment which they can't satisfy and they go into liquidation. So these are considerations. The court does not want to see your case until you have mediated or have gone through another form of ADR and it has failed, and then therefore the court has to deal with the remaining dispute. Now, this obviously means that you've got a choice as to when you may want to mediate, and that choice it is a wide-ranging choice, really. You need to know when is the best point at which you think there's going to be a best settlement opportunity. Usually matters don't mediate more than once, possibly twice, and often once the mediation has failed, it does mean that the parties then sort of feel more crystallized and they're going to go for it. They're going to double down and commit to the trial often, and so you don't want to get that moment to mediate wrong. It's worth undertaking a cost-benefit analysis, a simple form of really how much do you want to be rid of this case now? What's the cost of continuing with it versus the cost of dealing with it now and paying it out now? Might you be in a better situation in 6 months' time, having spent an extra £50,000 in costs, but you might have a potential better case? There's always the risk that you get you find bad information about your case in disclosure. For example, you might find that there's unhelpful documents come out of disclosure, and so you might want to mediate before that disclosure. You might want to mediate before you even have to go to the cost of defending a case, because it would be very costly to do so and it would be very time consuming. It would take you off your day job. There's all sorts of considerations, but in general terms, I would say there's decision points at pre-action, i.e. pre any pleadings at the court, post-pleadings, i.e. after the defence has gone in, so both parties know where they stand with their positions in general terms, a midpoint, perhaps after witness statements, and then last ditch right before trial, perhaps. Now, quick bit of case law, recent case law. This is a case where there was a refusal to mediate on 2 occasions, before issuing proceedings and after, before exchange of witness statements. And again, the court found that this was unreasonable, and there was a cost penalty applied of 50% of costs. So a substantial cost penalty there. Okay. I've done a little bit of a graph here. Obviously, lawyers with graphs not always a good idea, but I think this is helpful just to give a little bit of a feel as to a general position in any litigation. So we have here more costs or more of a desire to settle up the y-axis, and on the x-axis, of course, we've got time. And then we've got delineated by the dashed lines, we've got the various stages that are in any typical proceedings. You've got pre-action. So that's the pre-action correspondence, where we're setting out our case and we're explaining why we have a case and why they should pay up before we even bother proceeding any further. We've got to consider mediation at that point. It's specifically required. Preparing for the case management conference, that follows the pleading. So you put in your claim, you put in your defense, and then you have what's called the case management conference. Hopefully you can see my cursor. That's that second line there. Case management conference, the court then decides how the parties are going to proceed with disclosure, witness evidence, and expert evidence. And then you have a preparation for trial. Costs start increasing because you're incurring costs of the barrister who's reading in and getting ready, and that's his brief fee, or his or her, I should say. And then we've got the trial, and then you've got barrister's fees throughout the trial proceeding. Okay, but this is essentially showing the typical trend of how costs go up. And of course, as costs go up, you've got increasing stress, increasing pressure on the finances. You've got a desire, I would say, the desire to settle generally falls. And there's a couple of opportunities, I think, where you've got a good opportunity for potentially settling, and that is after you understand each other's case in the pre-action stage, and even more so perhaps after the CMC, when you've got an indication of all the work that you're going to have to do in this stage here, the disclosure, witness evidence and expert evidence stage, all that work that's going to take place. And as it may just tail off a little bit, the desire to settle, because you're coming towards trial. Maybe you've strengthened your position because you feel your evidence is nice and strong, but so do the other side, and they don't want to settle. And then as soon as you start incurring brief fees and all the costs of trial, no one wants to settle, because we're now in here for the end of trial and we want to see what the judge has to say about it. That's a very general picture. And why I would say you don't want to delay mediation too long if you can avoid it, because of that increasing or decreasing likelihood of a desire to settle as costs increase. And also, just to add to this, there's your frustration line as well, and there's your staff distraction line. If someone thinks you have a simple case at the start of it and you're still proceeding through disclosure, witness evidence and expert evidence and preparing for trial, you will have all your top staff potentially dealing with this matter and not dealing with other things that could be more worthwhile. Okay. Now, this is all bearing in mind this would be completely affected by such things as Part 36 offers, those special offers with potential to have a cost implication if refused, and that would change this picture. But in general terms, this is what I'm flagging, that if you're going to mediate, you want to be looking to mediate potentially quite early on, and really the only thing that should hold back on that is if you are lacking information which doesn't enable you to understand the case to a sufficient level. And in that case, you need to be asking the other side to provide that information, and there's lots of mechanisms by which we can do that and require them to answer questions if their case has not been fully pleaded out. But that is a topic for a different session. I'm afraid there's a large area to cover on that. Now, preparing for mediation, if we absolutely had to, we could get ready for mediation in 2 or 3 weeks, depending on the complexity of the matter and how much we'd already received in terms of a briefing on it. But the parties really need to make the most of this time. And typically, depending on the amount of analysis on figures or expert evidence that needs to be done, that period of time could be an awful lot longer. And it's going on at the same time as your preparation for any litigation. Quite ordinarily, you would expect that to be going on, but mediation to be considered. And so all of the information that you're gathering in that process is feeding into where you come to in the mediation discussions. Now, practicalities, we obviously deal with this, to identify a suitable mediator who's actually available. The good ones are quite busy, can be very hard to find specific dates that work for everyone. Some parties will want a neutral location, a hotel with conference facilities between the parties. Of course, this can be slightly frustrating when both solicitors have perfectly good locations either end, and ordinarily we would say it doesn't make a huge amount of difference. It's actually about what's said on the day and what the mediator does on the day. Okay, the location is neither here nor there really from our point of view, but people do sometimes get hung up on it. And if the other side does, maybe just go with it. We would say, it's not the big picture. Travel, accommodation, facilities, catering, all of that needs to be dealt with. Not to worry about. The main thing to consider is the exchange of papers. Now, what we are not doing is we are not repleading the case in any way. The case stands as it is. You might have by this stage, say we are mediating after the case management conference, and that is before we've done witness evidence and before we've done disclosure. But you've got a pleading bundle that says what the claim is, what the defense is, and any additional statements on those to flesh out those positions. Now, what you produce for the benefit of the mediator is a summary of the claim that is pretty straightforward, doesn't really step on anyone's toes. It makes sense from both sides. It's reasonable. It maybe points out where the differences are between the parties. A brief mediation bundle, and then the parties also have mediation statements, position papers. And these are designed really just to say what your position is in short terms, and I'll come on to that in a moment. Also, I would suggest you speak with the mediator, you get to know them slightly, you know who you're going to be meeting on the day. He or she will discuss any queries that they have, having reviewed the mediation statement, and you can put those right if it's not quite understood. And you can also say what you're looking to get out of the mediation, so the mediator really has an idea as to what that is. There's also a need to sign mediation terms. Now, these are terms that ensure both parties keep confidential the information that's passed between them, and will only be bound once the settlement, if a settlement is reached, is put into written terms. Now, preparing for the mediation internally, what do you need to be doing? This is a crucial phase because you need to be getting everybody on board within your business to appreciate what the mediation is about, what the outcome can be, and what they are happy with. So you need to identify who really needs to be there. You want the minimum number of people that have the most important roles. You don't want too many people, too many cooks spoiling the broth, of course. What you want is the people who really understand the claim, who might be the key witness or key witnesses, maybe 2 or 3 maximum. Then you've got somebody who is a senior member of staff who can make that decision and who can actually bind the business. Okay, you don't have counsel typically. We don't really want a barrister there because we don't need to discuss legal issues to that level of depth. If you do, you're unlikely to settle. Now, internally, a discussion needs to take place as to that cost-benefit analysis, and we can feed into that from a legal perspective and evidential analysis of what's available at the time. You need to work out what your absolute red lines are. You want to know whether you want a complete clean break from this other party that you've fallen out with, and you want to know what the other options are. Would you be interested in non-pecuniary outcomes such as a new contract or an apology or a revamping of the service they're already providing? Whatever it is there an option that doesn't involve money? Because that gives more options. If there is a financial limit the other side are up against, they may be able to find a way that they can settle if we can offer up those options. Now, you need to consult other parties like insurers and third parties as necessary, get approval from the board with clear limits, and grant authority to a particular individual who's going to attend. Now, the position paper that I mentioned, once or at the same time as those discussions are taking place internally, a position paper is being produced by us, which sets out in short order really a few pages. Usually the mediator will specify what they want, and the purpose, the audience really for this position paper is the mediator, so they can understand the case. You're not going to change your opponent's view just by rewriting your pleadings and sticking it in a shorter form. So I would say keep it brief, keep the figures front and central, really, right on the first page, a tabulation of what you say you're asking for, show some reasonable workings, and if you need to, provide a small bundle that supports that. But don't go into such detail that it will not be practical to review that material on the day, because it's just confusing matters. It's unnecessary. You want to keep your case simple, because simple cases are easy to understand, are easy for the mediator to grapple with, and ultimately they'll be easy for the court to deal with. So if you haven't got a straightforward case, you should probably be rethinking whether you want to take it all the way to trial. So as I say, do not regurgitate your pleadings. Do not simply say your case is great and how much it should be appreciated and how the other side has no prospect. That's not going to work either. And also don't introduce new issues without very good reason, because that just unhelpfully creates another barrier towards a settlement. If there is something which has come up at the last minute, consider discussing it with the other side in advance, maybe delaying the mediation, or maybe just flagging it before throwing it in there on the day or in the position paper. You want goodwill on both sides if you're going to get a settlement. Now, on the day of mediation, those who are attending must commit to the day. Don't have your phone on taking calls on other matters. Don't be checking your emails. Put an out of office on. Only be contacted on this issue. So wherever it is, it's a 9 a.m. pre-meet usually. That would be between us and you. We would meet the mediator a little bit later in a private room. Obviously, first option to meet the mediator ordinarily in person. Again, you reiterate what you're looking for of the day. The mediator might tell us what previous discussions they've had with the other side, might get a bit of a heads up on what to expect. And then what starts is a roundtable session, usually about 10 a.m., where the parties have an option to give a statement, say whatever they want to each other. It's all confidential, it's all without prejudice, and they can simply say what they want to. Now, it might be that someone shouts at you, might be that someone just simply says, well, this is a very commercial matter, and if you're not willing to pay the certain amount that we're looking for, then that's it. However you want to take that session, they can be long or short. The mediator will cut it short if it's not productive in their view. And so then it goes through into what we call shuttle mediation, which is room-to-room mediation with the mediator moving and sharing information between the parties. There's a working lunch to keep things moving. You might then see first offers between 2 or 4 p.m., possibly later. And then ultimately you get the settlement signed in the evening, and it can go on as late as it needs to, but it gets done on the day, and that's the important thing. Now, the role of the mediator, he or she is an experienced individual who has spent time in the sector, the legal sector, often a barrister, sometimes a solicitor, and sometimes somebody who is perhaps a QS or an accountant, somebody who has a specific training and experience which makes them suitable for mediating a particular area. And when we are considering which mediator to use, we would obviously look at their CVs and work out who might be best to have their experience drawn upon. Key thing is they're independent. That's not to say that we won't have used them previously, but they're independent of Devonshires, they're independent of your business, of the other side's business. And if there are any potential issues, then they get flagged early on. They don't make a judgment. They are not sitting in an adjudicative role. They are simply looking at the information, and they are using their skill set from their experience to identify what the risks for both parties are and to get the parties thinking about those own risks. Now, the discussions they have with each party are confidential, unless you want to pass information across to the other side, such as an offer or extra information about your claim and why you actually say it's stronger than they really believe. You would specifically instruct the mediator to pass over specific information, and the mediator would be bound to that. They can't just walk into the other room and say, whatever they want about your case, really. The mediators we use would usually describe themselves as facilitative. So they are there simply to facilitate a negotiation. And the advantage is that as soon as you walk out of a room of a negotiation, your position tends to harden. Whereas having a mediator present, mediator will seek to remind you of concerns regarding your case, of the potential upsides of the other side's case, of the costs of carrying on, and generally what they can then do, knowing and having those discussions with both parties, drawing on their experience, they can identify issues that are suitable for discussion that may result in a settlement. And so they won't tell you what that settlement is, but they will talk about the areas that are most likely to yield a settlement, and they will guide you through passing those offers and information between the parties, and also facilitating side meetings between individuals to share information and give you that opportunity to meet your opponents face to face, perhaps for the first time in a long time, or maybe even first time ever, and have those discussions. And that facilitation is key. That is what the mediator does, and that's how you end up with settlements quite often in these mediations. Now, typical tactics which people adopt, I won't spend too long on these. These are things which I don't necessarily think you should do. There's a time and place for them. We've seen all of these before, and they tend to happen in the mediations that don't succeed. Now, in the plenary session at the start, you often have people who just want to shout. That's fine. If that's what someone wants to do because that gets something off their chest, then I would say let them do it. The mediations we go to, our clients, we seek to have commercial mediations where the bottom line has to make sense. And if someone is frustrated and someone doesn't want to settle because they are angry at how they've been treated or how they perceive they're being treated, then it's best to let them shout. Okay, it's not something which I'd suggest is any benefit towards a commercially minded party, but if they need to do it, they need to do it, and that's the purpose of that opening session. Now, some people will come in and say, "We're not here to settle. We're here to listen. That's the process. That's what we're doing today." Again, that's not what mediation is about. Mediation, everyone needs to go into with an open mind as to a settlement. It's a nonsense to say that no one's going to settle for anything there. You don't know what's going to be offered. So just to say you're here to listen is unhelpful. If you just want to listen, you don't really need the mediator there. It's not purposeful. And if someone is just saying that, they just want to know more about your case. And perhaps you need to look at what they don't understand about your case, how you can rephrase it or reframe it. And perhaps you need to say to them, though, look, this is the process here is a process in which you should be engaging, and we don't think you are actually mediating here, and we will flag this up with the court in due course, and obviously threaten to raise it as a cost issue later on if they refuse to mediate and it has to go to trial. Now, some people will say, look, we are an immovable object here, we are at 4 million, we will not accept a penny less. Again, unhelpful, but it's a position that usually is just obviously just a negotiating position. You just say, look, yeah, by 3 p.m. they're talking about figures lower than 4 million. That's fine. That's fine. It's unhelpful to set yourself up in that position because you are simply going to show yourself later on not to be taking that approach. And the same thing happens to people who say we're leaving if we don't settle by lunch. Seen it happen, and they've always stayed to have lunch, and long into the evening as well. So that is just, if you're setting yourself up and saying that doesn't help your case, frankly. And the we've already packed our bags approach can be helpful. It's an approach used by people who've put down an offer, who have potentially a draft settlement going between the parties, and one party is simply holding out, wanting to get an extra term put into it, or an extra payment, and you simply say, well, look, we're already gone. This is a final option. We're going. Do you want us to sign or not? Happens an awful lot, and you do see people marching out of rooms and coming back in. So they're very typical tactics. There's time and place for all of these things, but not always productive. Now, the suggested approach I would have is that you demonstrate willing. You are there with an open mind to settle on the day. Everyone knows this is not a sign of weakness, but you've got to stick to your red lines. You need to know exactly what your limit is and what you can go to, and you don't want to walk out the following day with a signed contract, taking it back and discussing it with the board and saying, well, yeah, we thought we'd go for this in the end, but it wasn't quite what was agreed by the board. You need to be very clear, and if necessary, you need to get new instructions on the day from your board. As I say, we avoid taking barristers long because we don't want to get engaged in detailed legal or expert arguments. Those issues are not matters that the mediator can weigh in on. You can hear barristers on both sides give a legal argument. You can hear the solicitors back it up, and you can hear the parties convince themselves that they are satisfied with their position. But at the end of the day, the mediator is not going to make a determination. The point is, you've already pleaded, ordinarily, you've already pleaded your arguments either formally before the court or at least in writing. And so there's no need to regurgitate what you've already been saying. You simply need to look at the commercial reality. And you are saying, we are here today to see if a deal can be done. Bearing in mind the risks, sure, but we're here to see whether there's a figure that can be agreed that's mutually agreeable to both. Don't be afraid to make the first offer. Often there can be an offer already been made in writing. Don't worry if you're making another offer just because you were the last one to make one in writing. It gets things moving. Even if it's a high offer, you know that it's not going to get accepted. It gets things moving, and it gets the mediator into the other room and gets them talking with the other party about what is their offer going to be as a response. As I say, definitely think twice before ambushing the other side with new evidence. I have seen new evidence come out on a day of a mediation, and it simply resulted in the other party walking out. That's a waste of time and effort. It can be unhelpful because the strength of your new evidence might not be considered on the day. It might be put aside as being, we don't need to worry about this because we haven't got time to consider it. We need to consider what we know today. Actually, if you think you have a strong argument, strong piece of evidence, consider making it clear to the other side in advance, and being happy to really raise it on the day, but just presenting it as an ambush does not usually help the situation and does not lead to a good feeling between the parties, should we say. And make use of side meetings is a key thing. So a side meeting, essentially, you've got the mediator, maybe one individual from both sides in a room going through a particular issue, perhaps explaining a misunderstanding, explaining an approach, explaining figures. People who understand figures much more easily because they are the ones who are actually on the ground and dealing with the contract day to day, for example. And so they understand it really well. You might want to get them both in a room together. There's a level of person-to-person relationship there that can be exploited in a side meeting that can't be in the way that it can be in a full meeting. And above all, as I say, remain commercial. You're in there with a commercial mindset, with figures in mind as to what you're looking for, and don't throw everything away simply because you see it as a last-ditch effort. There's always the possibility, if you don't settle on the day, you will settle 2 days' time, a week's time, 2 weeks' time. Mediators typically remain available to assist as things progress for the next few weeks after any mediation. So they can be very helpful to drop back in. Now, just quick comment on COVID, really, as ever. There has obviously been a difficulty in doing face-to-face mediations in the last year. I have done some at times when we were allowed to. Currently, I think there's an awful lot of respect for the new systems that are available. Zoom, Teams, you can have breakout rooms and screen sharing, and it can all be coordinated by the mediator, so there's confidentiality is maintained, and effectively you just have virtual rooms rather than real rooms. It does work. It does work. It doesn't have that same atmosphere that you get in a mediation. It doesn't have the "we are here for the day to sort this out" sort of mentality, that sort of immersive atmosphere, as I say. So I would say if it can be done in person, it's probably best done in person. But there are certainly circumstances where I can see in the future we can mediate quite reasonably over video link, and that is, in cases where we want to do it very, very quickly, and the parties simply aren't available to meet any other way. Half-day mediations, the typical mediation is a day long, but you may have cause for just a small issue to be mediated or discussed over half a day, and that can be done in a mediation conducted online, which might just be more cost effective, really. Small disputes where the cost of travel and the cost of accommodation and location and the additional fees involved overall don't make sense, that can be done as well. International disputes where physically the parties are remote, and complex disputes where you can subdivide issues, and it might make sense that you have different working parties dealing with different issues at different times. But it's never going to be the same as an in-person mediation, and I'd say it's something worth looking at. It's something obviously we need to deal with on occasion these days, and I wouldn't discount it. But there is nothing quite like a day in mediation. And maybe, as you can understand, I quite enjoy mediations. You do see a lot of good outcomes. So I like to ensure that we consider them from an early stage. We don't discount them. Absolutely don't discount them just because we feel they're unlikely to succeed. And the only reason I would say hold off on one is really that you need to understand the other party's case a bit more. And in that case, as I say, there are things we can do to get that out of them, whether that's by request or by court order. And once you understand a case, there is invariably a middle line that suits both parties to some degree. And given the stress, the money, the time, the delay of going through full proceedings that can easily take 18 months, 2 years, there's often a desire to reach a commercial settlement early on. So I hope that has given you some good ideas as to the sort of tactics that we employ, the sort of expectations of a mediation, the court's expectations of what you need to do. And I would say, obviously, send me any questions. I know we're coming right up against the deadline now. I can't see that there's any questions as yet, but if you would like to drop me a note of anything, tell me about your experiences of mediation, I'd love to hear that. As I say, the case types really are across the board, and there are all sorts of cases that can be settled through mediation, and it really should be considered your go-to over and above litigation wherever possible. So I hope that's been really useful. I'm going to sign off now. Lots more to enjoy this morning and this afternoon, and I hope you do get to check into some of these talks. Thank you very much for joining me.